Viewers, you're watching the Explosive Exclusive with me, Rahul Shivshankar. The big news story is that Astha will not be delayed or shackled. The highest court of our land has decided not to intervene in the survey of the Gyanvapi Mosque complex, which Shiv Bhakts claim is one of the 12 Jyotirlings, as the survey, which establishes the presence, as it is claimed, of a Shivling-like structure in the Wuzu area of the Gyanvapi Mosque, has not been stayed despite the Muslim side questioning its validity. However, given the complexity and sensitivity of the issue, the Supreme Court has transferred the suit to the district court from the civil court. Even after 3 centuries since Aurangzeb allegedly destroyed the mandir, the Astha of Hindus has never wavered. Today, the mandir side claims Astha and truth have triumphed in a manner that they did not believe. Viewers, this is because the Muslim side in the Supreme Court wanted the entire survey stalled. The Muslim side said that a law drafted and passed by Parliament in 1991 called the Worship Act, which forbids changing the status of any place of worship in the country after 1947, 15th of August, ensures that the survey is not valid. But the Supreme Court has clearly not agreed and has not stayed the survey. This has led to a number of reactions coming in. Viewers, listen in.
जो आपने एक्सटेंशन ऑफ सर्वे भी मांगा था जी, एक्सटेंशन ऑफ सर्वे भी जो मांगा गया था, उन चीजों पे क्या एग्जैक्टली डिसाइड होगा?
एक्सटेंशन ऑफ सर्वे अभी हमने जो मांगा था वो कोर्ट वहाँ डिस्ट्रिक्ट जज डिसाइड करेगा,
वो डिसाइड
करेंगे। अभी सारी चीजें डिस्ट्रिक्ट जज वाराणसी के सामने हैं और कोर्ट ने ये भी कहा कि जो सिविल जज सीनियर डिवीजन है, हम उनकी कॉम्पिटेंस पे कोई कमेंट नहीं कर रहे हैं। हम सिर्फ ये चाहते हैं कि ये सेंसिटिव मैटर है, ये एक सीनियर जुडिशियल ऑफिसर देखें। वजू के लिए अरेंजमेंट किया जाएगा। चौथी बात, जो मुस्लिम पक्ष की एप्लीकेशन थी 7/11 की और प्लेसेस ऑफ वर्शिप एक्ट के आर्गुमेंट्स, वो भी डिस्ट्रिक्ट जज साहब देखेंगे। यही आज सुप्रीम कोर्ट का ऑर्डर है। उस एसएलपी को पेंडिंग रख के इसको 2 हफ्ते बाद लगेगा। 8 हफ्ते इंटरिम ऑर्डर कंटिन्यू किया गया है। अब जब इंटरिम ऑर्डर कंटिन्यू रहेगा तो कोर्ट ने कहा जो भी ऑर्डर पास होगा, जो हमारा इंटरिम अरेंजमेंट है वो कंटिन्यू रहेगा।
Viewers, there were a number of arguments that were made, and some of them are on your screens. The masjid side contended that great mischief is being done in the name of conducting a survey. The Supreme Court observed that it was looking for a healing touch and to strike a balance. Viewers, a lot more was said. Trial court, the masjid side said, has already run amok. The Supreme Court came out and said this is a matter of complexity and sensitivity. Also, it was said a fountain is not a Shivling. As per us, this is what the masjid side contended. The Supreme Court said lot more seasoned district bench must handle this entire issue. Even the Solicitor General of India, viewers, came out and said very clearly that the references to this alleged or claimed Shivling being a fountain is not acceptable. On this point, there was a massive clash, heated argument in court. Viewers, the 5 or 6 main takeaways are on your screens. Most importantly, the Supreme Court has refused to intervene in any manner as to adjudicate this matter. The Muslim side's pleas have been rejected. No stay has been imposed on the Gyanvapi survey, as was demanded by the Muslim side. The case has been given now to a district judge. Fifthly, viewers, interim arrangement. All the interim arrangements regarding securing the Shivling, access to the Wuzu Khana, the conduct of prayers, etc. in the mosque by Namazis are all being held up. So all of those stay, those arrangements stay. The 1991 law may not be a bar as of now, viewers. That's what the Supreme Court seems to contend. Now, viewers, we are going to go straight across to the two main contenders here. Let's go to Vishnu Jain and Abhaynath. Mr. Abhaynath, of course, represents the Muslim side in court. Vishnu Jain represents the Hindu side. Mr. Vishnu Jain, let me ask you, the Supreme Court has refused to intervene and refused to give you well, let me just go first to Mr. Abhaynath because he's connected. The Supreme Court has refused to intervene, Mr. Abhaynath, and give you the relief you expected. Is this a vindication of your stand? How do you see it?
नहीं, सुप्रीम कोर्ट, माननीय सुप्रीम कोर्ट का जो आदेश है उसको तो फॉलो करना ही पड़ेगा। उस पर आदेश पर कोई कमेंट हमारा नहीं है, लेकिन सुप्रीम कोर्ट ने जो मुकदमा सिविल जज सीनियर डिवीजन के यहाँ से डिस्ट्रिक्ट जज साहब को ट्रांसफर कर दिया, इसका मतलब ये हुआ कि इसके पीछे सुप्रीम कोर्ट ने सिविल जज सीनियर साहब के आर्डर को कहीं ना कहीं गंभीरता से लिया होगा, तभी ट्रांसफर किया होगा।
Okay, let me go across to Vishnu Jain. You've just heard Mr. Abhaynath. Let me ask you, Vishnu Jain, do you think that today the court has actually advantaged you? Do you feel vindicated?
See, the most important thing is that so far as the merits of the case is concerned, no order has been passed by the Honorable Supreme Court. The Supreme Court has remanded the matter back to the trial court and has transferred the case from Civil Judge Senior Division Varanasi to the District Judge Varanasi, and now the maintainability of the suit will be decided on the basis of priority. All the questions are left open. If we are saying that this particular property has religious character of a Hindu temple, that will also be seen along with the aspect of 711 of the suit.
Okay, but I just want to bring you back in, Mr. Abhaynath. You are saying that because this case has now been handed to a district judge, there is obviously something wrong here. But the Supreme Court has made it clear that it is not casting doubts on a judge. It is only doing so because it's a sensitive and complex matter. And perhaps a more experienced judge would be better served to carry out the further hearings in this case. So how can you still claim vindication, Mr. Abhaynath?
नहीं, तो ये तो सुप्रीम कोर्ट का आदेश अगर है तो वो उसके लिए हमारी कोई हम तो ये कह रहे हैं कि बल्कि एक तरह से सुप्रीम कोर्ट ने मेरे ही फेवर में ऑर्डर किया है कि वो सीनियर जज के यहाँ ट्रांसफर कर दिया। अब वहाँ सुनवाई अकॉर्डिंग टू लॉ होगी, वहाँ जो मेरा पक्ष होगा मैं उनके साथ रखूंगा।
But Vishnu Jain, you've just heard Mr. Abhaynath. How do you react? He says that because this case has been transferred, it tells you a lot.
See, the Supreme Court has very categorically mentioned today during the dialogue of the case that this order is not an aspersion on the integrity of the civil judge, since the matter is having sensitivity and it deals with a lot of public at large. Therefore, a seasoned hand should deal with such kind of important civil suits. And with regard to that, the matter has been transferred to the district judge, and it has no aspersion so far as the capability or so far as the impartiality of the civil judge senior division is concerned.
Abhaynath ji, मैं आपसे पूछना चाहता हूं क्योंकि ये जो 1991 का जो लॉ है जिसके तहत आप लोगों ने आर्ग्यू किया था कि ये पूरा सर्वे इलीगल है, आपकी बात तो कोर्ट मानी नहीं। सुप्रीम कोर्ट ने कोई रोक नहीं लगाई है सर्वे पर, और उन्होंने यहां तक कहा है कि 1991 जो लॉ है वो यहां तो एक किस्म से लागू ही नहीं होता।
मैं माननीय सुप्रीम कोर्ट के ऑर्डर से सहमत हूं, क्योंकि जो प्लेसेस ऑफ वर्शिप एक्ट 1991 है उसका प्रियम्बुल ये कहता है कि इज प्रोहिबिट द कन्वर्जन ऑफ रिलीजियस कैरेक्टर ऑफ एनी प्लेस इनटू अनदर रिलीजियस कैरेक्टर ऑफ अनदर प्लेस। लेकिन अगर उसमें कोई किसी रिलीजियस प्लेस का अगर कोई सर्वे हो रहा है, कोई कमीशन हो रहा है, तो उससे वो कन्वर्जन नहीं माना जाएगा। इस बात से मैं सहमत हूँ।
इससे आप सहमत हैं, मगर इसका मतलब कोर्ट ने आपकी बात मानी नहीं। विष्णु जैन, would you now say that this opens a Pandora's box or allows you now to go forward and make claims on other contested, disputed sites? Number one. Number two, and most importantly, do you think that today the Muslim side is now changing the goalpost?
See, I think as an officer of the court, I must not comment that whatever the dialogue has happened between the court, anybody's argument is defeated or it's upheld. The Supreme Court's order today is a very balanced order. And whatever dialogue has happened between the court, you as a channel can definitely play it, but as a lawyer and officer of the court, it will not be appropriate for me to rely on some observations or dialogues which has happened between the lawyer and the
I understand that, and one respects your discretion in these matters. Thank you very much, gentlemen. Thank you very much. Vishnu Jain Saab, thank you very much. Hope to see you later on in the evening. Let's open this up further. RP Singh joins us. So does Subhash Jha, Tausif Ahmed, Advocate Tala Amir Rashidi Saab. Let me bring in the Advocate Tala Saab as well as Tausif Ahmed first. Tausif Ahmed, I just want to ask you a simple and straightforward question. Would you today say that the Supreme Court has shot down your main contestations?
Of course not. Supreme Court has done what is expected of it. The matter is at a very premature stage. The matter is at the admission stage, whether the matter is maintainable or not, whether the court has a jurisdiction to pass any order of that sort. The question whether the Gyanvapi Mosque at on the day of independence had any character or not, had a character of a mosque or not, is not.
I am only talking about the arguments that were made. Mr. Ahmadi came out and said, apply the 1991 Act, stop this. This is an exercise in spreading canards, lies, exciting the situation. This is what he was arguing. And he said the 1991 Act has explicitly claimed that all this survey should not be done, and that this entire effort is to build a narrative state. That's what he was saying. In fact, he even went on to say, and let me quote him, that the court, the lower court, has run amok. But he said,
yes, and the Supreme Court has asked for the lower court to pass an order. After the order is passed, then the higher court will intervene.
Mr. Ahmadi said, don't allow this matter to fester on. Do not allow this matter to fester on. The Supreme Court has not agreed. How is this not a loss of face? आप कहते हैं कि do not allow this entire survey to continue. Supreme Court says no.
No, the submission was accepted.
How has it been accepted?
No,
the survey is continuing.
Supreme Court accepted it.
Sir,
that is why Supreme Court had said to decide on the maintainability.
Okay, let me bring in Subhash Jha.
The question whether the case is maintainable or not has to be decided. That is why the Supreme Court has asked to decide on the maintainability of the
Mr. Tausif Ahmed, the plea was very specific. The plea was stop the survey. Rok dijiye survey ko. I'm speaking now in Hindi to better help you understand what Mr. Ahmadi said. That has not happened. So how are you saying that this is exactly what you were asking for?
Let me. Okay, I will also speak in Hindi to better let you understand. जब केस फाइल होते हैं तो केस की मेंटेनेबिलिटी पे क्वेश्चन उठता है. आज मेंटेनेबिलिटी पे रूलिंग चाहिए. जब मेंटेनेबिलिटी पे लोअर कोर्ट की रूलिंग आएगी तो उसको चैलेंज किया जाएगा हायर कोर्ट में. वी हैव नॉट क्रॉस्ड दैट स्टेज.
Let me bring in Mr. Subhash Jha. Mr. Subhash Jha, how do you see what Tausif Ahmed is saying? I think you're mute, Mr. Subhash Jha. You put yourself on mute. Mute yourself, please. Thank you. Yeah, go ahead.
Mr. Tausif Ahmed perhaps could not comprehend what was the issue before the court. It was an application file. Can you hear me?
Yes, I can.
It was an application filed by the Muslim side under Order 7, Rule 11, saying that the suit itself is not maintainable and therefore it should be dismissed. Now that application is pending, and dehors that the court ordered that there has to be survey, videography. So there are two videography reports which are apparently before the trial court, before the Varanasi court, civil court, and senior judge who was hearing the matter. Now that was the order which was under challenge in the Supreme Court. Now the Supreme Court I beg to differ from the view expressed by the Supreme Court, but because this is not how it happens normally. The challenge before the Supreme Court was only with regard to the orders passed by the district court seeking to directing that there has to be videography that was sought to be stopped.
Yeah.
Now, why the High Court was circumvented, how the matter went to the Supreme Court, of course, I have to find out how it went to the Supreme Court.
That's a separate issue. Let's not go down that. The main plea was stop the survey. Am I wrong or am I right?
Absolutely. I'm sorry. No, there is absolutely no. There is no stay so far as the survey is concerned, considering the report of the videography is concerned. So all the options are open except that the Supreme Court in its wisdom thought it deemed it fit that the matter be tried by a senior judge, by the district judge, instead of the same being tried by the civil judge senior division. That's the forum changes. Now the rank of the two judges, except that the district judge is on a higher pedestal so far as the administration is concerned, they are one and the same. They are not different. So it goes from A judge to B judge. And the Supreme Court can do it in its wisdom. The Supreme Court thought it that there is so much of controversy, so let it be tried by some other judge. Let
me bring in Tala Ahmed Amir Rashidi. Tala Sahab, this is what Mr. Ahmadi said, quote unquote. Our SLP, special leave petition, is against the appointment of the commission. Remember, appointment of the commission. It is to prevent this type of mischief that the 1991 Act was enacted. The commission report has been selectively leaked to create a narrative. This is something your lordship must interdict. Varanasi court proceeding in violation of Places of Worship Act leading to great mischief. This is exactly what the 1991 Act wanted to avoid. So, he says, this particular commission must be stopped. The 1991 Act, the designate rule of that which he also cited, must be kicked in here, and the survey should be stopped. Supreme Court has not stopped the survey. In any case, let's go straight across to Mr. Owaisi's press conference, his first remarks on what has transpired.
Article 142 to do complete justice. The reason I say is that because if you look at the sequence and the chronology of the Babri Masjid whole issue, it started with Chabutra, then surreptitiously idols were placed, then unlocking of gates, demolition of Babri Masjid, makeshift temple was erected, then permission to pray in that makeshift temple was given, and then ultimately the judgment went against the Supreme Court title suit. The Muslims lost it, and in the criminal case not a single person was convicted. So that is why we are very apprehensive, and please remember that it is not one issue of Gyanvapi. We have recently seen that the district court have allowed a suit in the Mathura Eidgah issue, despite an agreement that happened between the Muslims and the Krishna Janambhumi Sevasthanan Sangh, which happened in 1968. Thirdly, there are many issues wherein the RSS and the BJP claims that at one point of time the masjids were not masjids. Coming to today's judgment, Supreme Court, as you must have heard, Supreme Court now has directed that the district magistrate will listen to this case. The Supreme Court has also said that the 7-11 will be heard on priority, and in that way the Supreme Court, by transferring the district magistrate, because the lower court honorable judge was listening to one side of what the petitioners were coming and telling him. Thirdly, the Supreme Court has said, has directed to the district magistrate of Varanasi that Wuzu arrangement should be made. In the earlier order of May 16, the Supreme Court has said that whatever is the religious observance should be allowed. In a pond if water is there, the Muslims do ablution and wuzu to perform the Namaaz. The Supreme Court have said that allow the religious observance, but it is very, very unfortunate that the local district magistrate is completely collaborating with the petitioners. If the Supreme Court have said allow the religious observance, and religious observance includes doing ablution and wuzu. So today's order also the Supreme Court have said that wuzu should be allowed, and I hope that Muslims will be allowed to do wuzu from the pond. The fountain that is there, which is now part of a judicial case, that can be protected. But the Supreme Court has said that allow the wuzu, because that is doing wuzu for a Muslim is part of religious observance, because I cannot perform namaz unless and until I do wuzu. So in every masjid you will find a place to do ablution, and that is the rightful place. Thirdly, the Supreme Court has said to preserve that fountain, or what the other side calls it. It can be preserved, but at the same time that pond should be open. So we'll hope that the district magistrate will hear it on priority, but my disappointment is on this issue that I was expecting that the Supreme Court will nip it in its bud, because this whole 91 Act categorically states that this act was made so that future controversies don't arise. So on that part, I was expecting the Supreme Court would nip it in its bud, because every day we are seeing newer issues are coming up. So this is my reaction to today's Honorable Supreme Court order, and the SLP is still with the Supreme Court, and we hope that the district magistrate will do justice in this matter and will hear it as the Supreme Court has directed, that the 7th order should be heard on priority.
सर, बार-बार आप 1991 का एक्ट याद दिलाते हैं, लेकिन आज सुप्रीम कोर्ट ने कहा कि जो आप कह रहे हैं वो सही है, लेकिन जो सीमाएं तय करने के लिए भी उसमें एक ऑप्शन है, ये भी सुप्रीम कोर्ट।
एक बात सुनिए, ये सुप्रीम कोर्ट ने क्या जजमेंट में रिफ्लेक्ट किया आज के ऑर्डर में अपने? बताइए। नहीं, आप बताइए। सुप्रीम कोर्ट ने नहीं कहा वो बात, बल्कि सुप्रीम कोर्ट ने ये कह दिया कि अगर किसी ज़ोरास्ट्रियन या किसी जगह पर किसी और मजहब का निशान मिलेगा तो क्या चेंज हो जाएगा? क्या वो
चेंज नहीं कर सकते?
हाँ, ठीक है, वही सही। तो नहीं, आप नहीं कर सकते। इसका ऑब्जेक्शन अहमदी साहब ने लिया, और आप पढ़ लीजिए क्या कहा जजेस ने। बोले कि हम मिसाल दे रहे हैं, तो वो ऑर्डर का हिस्सा नहीं है। तो 91 का एक्ट क्यों बनाया गया? 91 का एक्ट बनाया गया टू प्रिवेंट फ्यूचर कंट्रोवर्सीज। और हम तो ये उम्मीद कर रहे हैं कि चाहे सुप्रीम कोर्ट हो, लोअर कोर्ट हो, हाई कोर्ट हो, वो जो बाबरी मस्जिद के टाइटल सूट में सुप्रीम कोर्ट ने कह दिया कि 91 का एक्ट भारत के संविधान के बेसिक स्ट्रक्चर का हिस्सा है, हम पूरे कोर्ट्स को चाहेंगे कि उसको इंप्लीमेंट करें। वो 91 का एक्ट भारत के संविधान का बेसिक स्ट्रक्चर का हिस्सा है, इसमें कोई दो राय नहीं है, क्योंकि सुप्रीम कोर्ट ने कह दिया उसको। और जो अंग्रेजी में कहते कि वॉक द टॉक होना चाहिए अभी।
लेकिन सर, आप इसको बार-बार फाउंटेन है बोल रहे हैं, पर ये तो ऑब्जर्वेशन है ना कि ये शिवलिंग माना जा रहा है।
नहीं, वो देखिए, जो कोर्ट के जज ने बगैर मुस्लिम पक्ष को सुना, बगैर सर्वे कमिश्नर की रिपोर्ट साहब के पास गई, जज साहब ने दूसरी पार्टी जो दौड़ते उनके पास गई, उनको सुना, और बगैर मुसलमान को जो पार्टी है उसमें इंतजामिया कमेटी, बगैर सर्वे कमिश्नर की रिपोर्ट में उन्होंने गलत ऑर्डर दिया। इसीलिए सुनिए, ये सुप्रीम कोर्ट में बात रखी गई, और हम सुप्रीम कोर्ट ने अब डिस्ट्रिक्ट मजिस्ट्रेट के पास इस केस को भिजाया है, और हम उम्मीद करते हैं कि वो फेयर तरीके से इन तमाम चीजों को सुनेंगे।
लेकिन अब
मगर सर डिटरमाइन कर सकते हैं सुप्रीम कोर्ट
नहीं,
ने ये कहा
ऐसा नहीं, नो,
और अब तो अरेंजमेंट करने के लिए भी
नहीं, आप गलत कह रहे हैं। क्या वो ऑर्डर का हिस्सा है आज के? नहीं, देखिए, जो जजमेंट में कहा जाएगा वही फॉलो किया जाएगा। और सुप्रीम कोर्ट ने एक मिसाल देकर कहा, अगर आप ये बोलेंगे कि मस्जिद किसी और की निशानी मिल जाएगी तो क्या मस्जिद का कैरेक्टर चेंज हो जाएगा? वही नहीं, नो, ऐसा नथिंग डूइंग। वो गलत, आप लोग गलत रीड कर रहे। आप किसी भी सीनियर लॉयर को बिठाकर पूछ लीजिए जो मुझसे काबिल है, वो बोलेगा कि 91 एक्ट ये कहता है कि नेचर एंड कैरेक्टर चेंज नहीं हो सकता। और आप बार बार जो सर्टन की बात कर रहे, वो एक मिसाल के तौर पर कहा गया जो आज के ऑर्डर में रिफ्लेक्ट नहीं है।
सर क्लियरली मैं आपको पढ़ के बता दूं।
पढ़ के ऑर्डर बताइए। नहीं, सुनिए, नहीं, आप ऑर्डर पढ़िए।
सपोज
ऑर्डर पढ़, नो सपोज नथिंग, आप ऑर्डर पढ़िए।
सर जस्टिस चंद्र,
नहीं, आप ऑर्डर पढ़िए। आप सुनिए, देखिए, ऐसा नहीं हो सकता। आप नहीं, मैं आपकी बात का यकीन ही नहीं कर सकता। आप आज का ऑर्डर पढ़िए। चलिए बताइए मेरे को उसमें क्या है।
सर आप कह रहे हैं कि मुस्लिम पक्ष को बिना सुने ही उन लोगों ने वहां पे अरेंजमेंट्स करने के लिए वो प्रोटेक्शन करने के लिए कहा, लेकिन आज सुप्रीम कोर्ट ने कहा कि अरेंजमेंट्स होने चाहिए वहां पे वजू करने के लिए।
हाँ, तो सुनिए, जब अहमदी साहब ने कहा कि क्यों अल्टरनेट अरेंजमेंट, तो कोर्ट ने कहा अल्टरनेट अरेंजमेंट नहीं। सुनिए, सुन तो लीजिए। अल्टरनेट अरेंजमेंट ने क्यों जब पूछा गया तो कोर्ट ने कहा कि पानी मुहैया किया जाना चाहिए। पानी कहां मिलेगा? पौंड में मिलेगा? और नहीं मिलेगा। पानी पौंड के सामने नल की टूटियां हैं, वहीं पानी मिलेगा। और पानी कहां मिलेगा? कोर्ट ने कहा कि हम अल्टरनेट अरेंजमेंट की बात नहीं कर रहे। कोर्ट ने कहा अभी डायरेक्ट का लफ्ज इस्तेमाल हुआ है, और उस पॉन्ड के पास, वो पॉन्ड को और उस पॉन्ड में जो नल की टूटियां हैं उसको इस्तेमाल करेंगे वजू करने के लिए।
सर ये जो रेफरेंस किया प्लेसेस ऑफ वर्शिप एक्ट पे, इस पे आपका क्या कहना सर? क्या ये जो प्लेस सिंबल, जेरूसलम सिंबल पाया गया है
रेफरेंस के तरीके से।
अरे सुनिए, आप देखिए, वो उसके लिए लंबी बहस हो जाएगी। आप मेरे को बताओ वो जो आज के ऑर्डर में कुछ है क्या वैसा? बताइए। No. See, these are exchanges which the judges and the lawyers will have. Are you trying to elevate it to the judgment? Don't elevate that to the judgment.
But sir, there is a report which was leaked yesterday.
So yes, what did the court say on that? The report should not have been leaked, but the damage has already been done.
But the report also shows that they are evidence.
That the court has said the report should not be leaked. Now it has been gone to a district magistrate, and on priority 711, order 711 will be heard. That is the maintainability of this whole suit. पूछिए, आसान रुक जाइए।
91 के कानून की बात कर रहे हैं हर मामले में। क्या मुस्लिम पक्ष इस मसले को लेकर एक अलग से कोई मूवमेंट या कोई ऑर्गेनाइजेशन से इसको स्थापित करने के लिए कोई अपील दायर करेगा?
क्या है, फिर से बोलिए।
तो 91 का हमेशा हवाला दे रहे हैं, हर मामले में दे रहे हैं।
हवाला आपको भी देना चाहिए, क्योंकि कानून है वो।
तो क्या उसको मुस्लिम पक्ष पूरे टोटालिटी में ऑल इंडिया लेवल पे कोई जाके उस कानून के लिए आप लोग कुछ करने वाले हैं कि
नहीं? कानून को करने क्या, वो तो बेसिक स्ट्रक्चर का हिस्सा है, पार्लियामेंट का बनाया हुआ कानून है। हमको करने की क्या जरूरत है? हम इतना ही कह रहे कि सुप्रीम कोर्ट ने जब ये कह चुका कि ये बेसिक स्ट्रक्चर का संविधान का हिस्सा है, तो हम तो ये उम्मीद कर रहे हैं कि कोर्ट्स वॉक द टॉक करेंगे, बस, और कुछ नहीं। हमको वो बेसिक स्ट्रक्चर का हिस्सा है, पैराग्राफ नंबर 83 में। और ऑनरेबल जस्टिस चंद्रचूड़ साहब उस जजमेंट के जजेस में से हिस्सा थे।
Justice Chandrachud also said.
No. See, I am sorry. You are ignorant about this law. You cannot call the exchanges between the honorable judges and the lawyers as a judgment. Please don't do that. No, please don't do. No, don't do that. No, don't do it. You are completely on the wrong path.
So first of all, order copy is not out.
In fact, I am telling you, you will be hauled for contempt of court. Don't do it.
Order copy is not out yet.
So, order copy is there. You see on the live law, bar and bench, it is there. Go and see it.
सर
सुप्रीम कोर्ट में ये तेलंगाना के मुतालिक एक इनकाउंटर हुआ था, उसके मामले में भी डेवलपमेंट आया।
मैं हर एनकाउंटर के खिलाफ हूं, चाहे वो चंद्रबाबू नायडू के जमाने में अजीज और आजम का एनकाउंटर हो, चाहे सोहराबुद्दीन का एनकाउंटर हो, चाहे वो नईम का एनकाउंटर हो, चाहे ये जो शमशाबाद में एनकाउंटर किया गया है, मैं हर एनकाउंटर के खिलाफ हूं।
That was Association of AIMIM there going on to say that it was only an observation as far as the 1991 Worship Act is concerned, and they cannot allude that to the judgment. There has been absolutely no change as far as what they claim is also a vindication of their side. They say that it has gone back to the district court where the case will be heard. Meanwhile, status quo continues as far as conducting Namaaz and Wuzu is concerned in the Gyanvapi Mosque.